Hello, my name is Ruben Benitez, and this is a brief legal analysis on Bollea versus Gawker. This analysis is produced for Criminal Justice 401, Cyber Ethics, Policy, and Law. Now, a brief overview of the case. In 2006, Terry Bollea, professionally known as Hulk Hogan, engaged in an extramarital affair with Heather Clem. Unbeknownst to Mr. Bollea, this encounter had been video recorded. The video of this encounter was subsequently leaked by an anonymous source to Gawker Media. Upon receipt of the video, Gawker Media proceeded to create a highlight reel focusing on the more salacious aspects of the video, as well as producing a written transcript. Both of these items were subsequently used to create a news story which was published on Gawker.com. Once the story was published, Mr. Bollea filed suit against Gawker Media for invasion of privacy and the intentional infliction of emotional distress. Now, in order to be successful, the essential elements of a tort have to be proven. In the case of invasion of privacy, the essential elements are intrusion into one's solitude or into one's private affairs, public disclosure of embarrassing private information, publicity which puts an individual in a false light to the public, and the appropriation of one's name or picture for personal or commercial advantage. For intentional infliction of emotional distress, the essential elements are outrageous conduct by the defendant's intention of causing or reckless disregard of the probability of causing emotional distress, the plaintiff suffering severe or extreme emotional distress, and the actual and proximate causation of the emotional distress by the defendant's outrageous conduct. Now, this matter was ultimately decided by a jury, which found Gawker Media liable and awarded Mr. Bollea a substantial monetary award. However, upon my review of the facts of this case, I have found issue with that decision and believe that not all of the essential elements for either one of these torts was successfully proven by Mr. Bollea. Now, it's not argued that Mr. Bollea did in fact suffer emotional distress because of the release of the video and subsequent news story. Mr. Bollea was uh, obviously emotionally distressed because a sex video of him had been made public, showing him in a state of undress engaged in a sexual activity. He was likewise in fear of the possible impact that the release of the video and the news story could have on his professional career and social standing. Um, in that vein, Mr. Bollea did prove elements for both invasion of privacy and the intentional infliction of emotional distress. However, when it comes to invasion of privacy, Gawker Media did not create or solicit the creation of the video, and it could be argued that the intrusion into Mr. Bollea's privacy had already occurred by the time that the video was provided to Gawker Media. Um, Likewise, Gawker Media argued that their publication of the news story uh, was in furtherance of information that was of public interest. Now, Mr. Bollea had previously spoken about his extramarital affairs in interviews and also wrote about it in his autobiography. As a result, Gawker Media argued that the information was already public and their news story just added to the discourse that was already surrounding Mr. Bollea's actions. Um, Based on this logic, the publication did not put Mr. Bollea in a false light with the public, seeing as how the information had already been put out there by Mr. Bollea himself. Mr. Bollea also argued that Gawker had unjustly enrich themselves through the use of the video in his name. Um, However, um, Gawker Media argued that they had not directly profited from the video, and in fact, Gawker Media's news story and access to the video was on their publicly available website. They did not charge for the video or access to it, and any uh, commercial gain was residual gain based on the increase of traffic flow and increased ad revenue to the site, and it was incidental to the news story and not directly tied to it. And in regards to the intentional infliction of emotional distress, once again, Gawker Media did not create the video um, or solicit the video, so the conduct in and of itself was not outrageous. The publication of the video was in furtherance of a news story, and as such, I do not believe that Mr. Bollea was able to meet that essential element for intentional infliction of emotional distress. Um, However, uh, the remaining elements of reckless disregard for the probability of causing emotional distress, the fact that Mr. Bollea did suffer extreme emotional distress, and that this was caused as a direct result of the publication of the news story, was proven. However, as stated previously, all elements need to be proven in order to uh, have a successful case, and in this instance, not all of the essential elements of the tort were satisfied. Therefore, based on this analysis, I believe and I find that Gawker Media was not liable for the invasion of privacy or for the intentional infliction of emotional distress. Now, the ethical dilemma at the heart of this case, the central issue, is freedom of the press. And should there be a point at which news outlets are held liable for reporting on factual yet distasteful or uncomfortable news? Now, the ethical perspective that best fits this issue would be moral duty, moral as derived from the philosophy of Immanuel Kant. In essence, this states that moral action should be motivated by duty or obligation rather than the achievement of an optimal result. Applying this perspective to the question at hand, freedom of the press and the ability to report on matters of public interest, regardless of the possible negative or positive effects to the parties in question, would be paramount. Ruling against a news organization and finding them liable for invasion of privacy or inflicting emotional distress could have a chilling effect on the press. Although the content of a particular news story may be shocking or distasteful to some audiences and could result in the loss of reputation or standing for individuals subject to the reporting, these negative outcomes do not outweigh the duty of the press to freely report on issues of general import. Holding otherwise could undermine freedom of the press and stifle free access to information. I hope that you have found this analysis uh, insightful, and thank you for joining me.